Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. This is the episode for December 4th, 2022. And this week I'm going to be focusing my attention on two pieces of legislation that were introduced recently in Alberta and Saskatchewan. And these pieces of provincial legislation, somewhat ironically given their content, have issues which I think are national in scope. They've been in the news nationally, and so I wanted to talk about them today with you and just discuss some of the legal elements of them. They're both pieces of legislation that talk about the division of powers between the federal government and the provincial governments. And in both cases, the provinces, Alberta and Saskatchewan, are asserting through provincial legislation their own sovereignty, their own priority or standing within the Federation, within Canada. So I wanted to give you my views on those. There's been lots of media attention on these, some legal analysis, but I don't think you'll get exactly what I'm going to be talking about today from any other source, not exactly what not from what I've seen anyway. So I hope you'll enjoy that. Before I talk about that, I'll just a little quick recap of the week that was. I was busy this week. I was on a couple of radio programs. First, I was on 6:30 CHED CHED in Edmonton on Monday talking about the Emergencies Act inquiry that wrapped up a week ago, Friday, I guess, and with the testimony of the Prime Minister. And what I was talking about there with the morning crew, with Daryl there, was just how the jurisdiction, I guess the legal elements of that, and how I think Justice Rouleau, is going to take a wider scope into what could be qualified as an emergency. There was some debate as to whether there was a narrower definition under the CSIS Act, which the judge would have to follow. I think he's going to go for the broader definition that the government was advocating, although they didn't quite get to disclosing what legal advice they'd been given. But listening to the Prime Minister's testimony, one could kind of see what advice the government had been given by sort of reading between the lines in his testimony. So that was interesting. Then I was also on City News Ottawa with Rob Snow on Wednesday, talking about just comparing the Mass Casualty Commission inquiry in Nova Scotia to the Emergencies Act inquiry, and some of the things I think the Emergencies Act inquiry got right that the Mass Casualty Commission didn't. A lot of it had to do with timeliness, but also with examining witnesses. So consider, in the Emergencies Act inquiry, the Prime Minister of the country was on the witness stand and was being cross-examined by different parties, including the convoy lawyer, Civil Liberties Association lawyer. And compare that to the Mass Casualty Commission, where most of the key witnesses did not face cross-examination. And so some distinctions there. So if you want to check out some of those interviews, I'm sure they're online there, and you get some of my thoughts, or you can refer back to previous versions of the Rogers Brief. So normally in these weekly videos, I'll cover a range of 4, 5, 6 stories that are in the news. This week I want to focus, because I'm going to focus basically on one story, but there's 3 elements to it. All right, there's the Alberta legislation, which is called the Alberta Sovereignty. Well, I'll read it here. It's right here. The Alberta Sovereignty Within a United Canada Act, and it is Bill 1 from the Alberta legislature under new Premier Danielle Smith. And the other is the Saskatchewan legislation, which is Bill 88 in their legislature under Premier Scott Moe, and it is an act to assert Saskatchewan's exclusive legislation jurisdiction and to confirm the autonomy of Saskatchewan. So it's a mouthful, certainly, as a title. The third part I'm going to analyze is a 2021 Supreme Court of Canada decision, which I think in a sense certainly prompted the Saskatchewan legislation, probably also had an impact on Alberta's decision to bring forward their own legislation in this regard. And that was a decision on carbon pricing that the Supreme Court of Canada was asked to make, and they did in favor of the federal government on a 6-3 split decision. So I'll talk about all of those three things. So, before I get into that, a reminder or a note that I'll be on the nighttime podcast tonight with Jordan Bonaparte and Paul Palango, and that is at 9:15 Atlantic time, and we go live on YouTube. So you can go to nighttime podcasts on YouTube. Just do a search for that, and you'll find the links for that, so you can watch live. And then in a few days' time, he posts it also as a video and a podcast link, so you can listen in on that. We'll be talking about the latest developments in the Mass Casualty Commission inquiry, which wrapped up hearings in September, and yet there are still new details being released every week. There were some new exhibits posted to the Mass Casualty Commission website this week, and then there was a couple of articles in the news about the helicopter situation. For people that wouldn't be familiar with that, or just a reminder for those that are, during the early moments of the mass casualty events, the RCMP was looking for a helicopter to get into the area with infrared heat sensing capabilities to find the killer in the woods, because it was a wooded area, in a rural area in Nova Scotia. The RCMP helicopter was down and was out for repairs, which was known, but there was no backup plan. They tried to call the military, who weren't that far away, and they had a helicopter with the capabilities. Military figuratively and actually literally told them to go pound sand, I think, from the news reports, so they weren't able to use the helicopter. There was no other backup in place. They ended up having a natural resources helicopter in the morning, but it turned out not to be really of any help. So we'll talk about those new developments, a couple of other things that came along tonight at 9:15 Atlantic time. So join us there on the nighttime podcast. Okay. So the news this week, and this has been getting lots of, I think, overheated, elevated rhetoric attached to these two pieces of legislation in Alberta and Saskatchewan. So let's go through them first, and then I'll talk about some of the commentary that's been out there. Okay, so it's Bill 1, first of all. Maybe that's maybe the first thing to think about, and an important thing to note, because this is the first piece of legislation that Danielle Smith, in her role as Premier, is introducing to the legislature. And I think there's a purpose behind that too, is to set a tone for relations between Alberta and the federal government. Okay, so it's called, again, Alberta Sovereignty Within a United Canada Act. And they're making a statement that they're going to push the federal government on all things where they think the federal government is interfering in provincial jurisdiction. Okay? So, and the bill authorizes the legislature to spend money on studies. So if they feel like the federal government is infringing on provincial jurisdiction, on environmental issues or anything else, but it seems to be mainly directed at natural resource developments, the economics behind all of that, and environmental regulations and laws that are coming down from the federal government that would affect or interfere in their minds with those natural resource developments. Okay, so the preamble is kind of interesting. The first sentence is, whereas Albertans possess a unique culture and shared identity within Canada. Well, that's probably true. You could say that about any province, I guess, and that's part of the idea of federalism, that each province has its own identity and unique culture. Note that they didn't you say, oh, they're pretending they're like Quebec. Well, not exactly. They're not claiming to be a nation, quote unquote. A nation is something that is, the Quebecois are a nation. Albertans are not a nation, but they have a unique culture and a shared identity. Okay, so that's fine. A few whereases later, it says, whereas actions taken by the Parliament of Canada and the Government of Canada have infringed on these sovereign provincial rights and powers with increasing frequency and have unfairly prejudiced Albertans. Well, okay, so nobody's asking anybody to prove that things are happening on an increasing frequency, but this is the claim that the provincial government is making. And then the next section is part that says actions taken by the Parliament of Canada and the federal government of Canada have infringed on the rights and freedoms of Albertans enshrined in the Charter of Rights and Freedoms in an unjustified and unconstitutional manner. So basically what they're saying is the federal government is infringing on provincial jurisdiction, and so they're using this legislation as a means to fight back and push back and assert their provincial jurisdiction. So what does it mean? You know, it says in the Canadian Constitution, in sections 91 and 92 of the Constitution, there's a list of things which are provincial jurisdiction, like healthcare, like natural resources, like the structure of the criminal justice system. Lots of things which are provincial jurisdiction. Community services, provincial taxation, all of those things. And then there's other jurisdictional items which are federal. I'm going to get into that a little more when I talk about the Supreme Court of Canada decision, but there's a list in both cases of which ones are provincial and which ones are federal. But when something is not listed, then by default it typically becomes the federal government's jurisdiction. Not exactly, but we'll get to that too. And of course, there's some issues like environment, like criminal justice, like health, where there's some federal elements and some provincial elements to the jurisdictional question. Okay. So what is Alberta trying to say here? Well, they say right away in Section 2, nothing in this Act is to be construed as authorizing any order that would be contrary to the Constitution of Canada. So what they're explicitly saying they're not doing is trying to unilaterally change the Constitution of Canada by claiming federal powers. So they're not saying, hey, we are now just declaring that we're now in charge of immigration for the province of Alberta. That's not the claim they're making. So they're not saying anything that isn't effectively already part of the law of the country through the Constitution. But what they do is in sections 3 and 4 is allow for, if the Cabinet of Alberta feels that something has been done by the federal government to infringe on provincial jurisdiction, then they say if on a motion of a member of the Executive Council, which is the Cabinet, the Legislative Assembly approves a resolution that, in Section B, states that in the opinion of the Legislative Assembly, a federal initiative is unconstitutional on the basis that it intrudes into an area of provincial jurisdiction. Okay, so what would happen then in practical terms is the legislature of Alberta could say, hey, this new environmental legislation that the federal government is bringing in infringes on Alberta legislation and on Alberta provincial jurisdiction. And they can pass a motion to say that they feel it is unconstitutional. They have to not only say that they feel it's unconstitutional, but also setting out the harm that would result from that. And then also in Section 3, they say identify a measure or measures that the Lieutenant Governor and Council should consider taking in respect of the federal initiative. Okay, so if those things are done, then the Lieutenant Governor and Council, which is the Cabinet, can take the actions described in Section 4. And Section 4 says that they could suspend or modify the application or operation of all or part of an enactment, so ignore the federal enactment, or specify or set out provisions in addition to or instead of any provision in an enactment. So they can change legislation without going back to the legislature to do so in the normal course of events, first, second, third reading, it passes the legislature and you have a new law. Well, in this case, they're saying the minister responsible for whatever the area of jurisdiction is could set out and change the legislation, the regulations. And you can issue directives to provincial entities as well. Now, whenever that is done, Section 5 says that the authority, the order that is made under that system would cease to have any effect after 2 years' time. So there's a 2-year window on this, similar in sense to the 5-year window that is used in the notwithstanding clause. If any provincial legislature passes something and utilizes the notwithstanding clause, that is has to be reenacted every 5 years. In this case, it would have to be reenacted every 2 years. Okay, so to me, when I read this and I see there's lots of people saying, well, this is, they're going to break up the country, they're looking at starting a fight and all this. Well, they're certainly looking to start a fight, but I don't think there's the need for the elevated, escalated rhetoric that I've seen out there. There's some issues about, all right, well, if they feel that the environmental legislation from the federal government is infringing on their provincial rights, they could fund a study into that, come back with, okay, the study's concluded that these are the infringements. They could have a legal opinion that backs that up, and then take that report back to the federal government and say, listen, this is what we think, that you're infringing on our rights. Can we talk about it? Or they would take the federal government to court if they disagreed and use whatever report they had drafted as the basis of their claim for judicial review in court. So really all of this legislation is a statement of saying, this is, we think we want people to respect the provincial jurisdiction, and if they don't, we're going to do reports, take study, take action, and potentially amend legislation or order provincial employees not to enforce federal rules if that's the expectation. Certainly that could be the case in criminal justice issues, because the federal government sets criminal laws, but it's the provincial government which organizes the courts and does enforcement, has control over the police. So there could be some disputes in that area, depending on what the legislation was that was brought in. There was an issue that came up as well, I saw this week, with some commentary that, this is going to take away democratic accountability and effectively make the cabinet into like a king or queen like sovereign. But I don't see, I could see that concern, because one of the powers in Section 4 is that they'd be able to enact legislation or amend legislation if that was seen to be the way to ward off the federal intrusion. But any such amendments to legislation or whatever are going to have to be reflective of whatever the motion was that was passed by the legislature. So if the legislature passed a motion that says there's federal infringement and this is what we think we need to do, and then the minister went off and did something completely different, well then somebody could apply for judicial review and have that, whatever was done by the minister in violation of what the guidance from the legislature was, that could be struck down. Of course, these things take time, and so there's some effects of having, improper laws on the books for even a short length of time. But I don't see it as being equivalent to, all of a sudden we've got a dictator system in Alberta. That's completely overblown rhetoric and unnecessary. I want to talk a little bit about Saskatchewan now, because the Saskatchewan legislation is actually quite similar. It hasn't gotten quite the attention as the Alberta legislation has outside of Saskatchewan. It's Bill 88 and not Bill 1, so it's not an introductory piece of legislation in Saskatchewan in the sense that it is in Alberta, but it has many of the same elements. So in the Saskatchewan legislation, they also repeat this as where the government of Canada has unilaterally intruded. So that's a statement, not a, you know, it's saying that they've already done this and that they're causing economic harm to Saskatchewan by doing so. And it says also that Saskatchewan resolves to never be less than an equal partner within Confederation again. Well, they're not supposed to be junior partners in Confederation. There's provinces, there's the federal government, each has their responsibilities. But anyway, that's a statement of, I guess it's projecting how Saskatchewan feels they've been treated by the federal government. So there's three parts to the Saskatchewan legislation. Part one gives the legislature of Saskatchewan exclusive jurisdiction over certain areas like the exploration of non-renewable natural resources, the development and management of non-renewable natural resources, the development and management of forestry, the production of electrical energy, regulation of industries covered by provincial jurisdiction, including environmental regulation. So effectively, I think they're trying to exclude the federal government from environmental regulation on anything that is provincial jurisdiction. I'll come back to that. And the regulation of fertilizer, because farming is important in Saskatchewan, and so they feel they should be the only ones that are regulating how fertilizer is utilized on their soil. The second part just does some amendments to the Saskatchewan Constitution that sort of result from these earlier declarations. And then the third part creates an economic impact assessment tribunal. Now, Alberta did not do this in their legislation. I think they might have been wise to do so and follow Saskatchewan's example here, because it seems to me what Saskatchewan is trying to do is create something similar to the Utility and Review Board that we have in Nova Scotia, that is a non-partisan quasi-judicial administrative body that, you know, hears evidence and makes decisions that can be respected but that can be appealed within the regular court system. In Alberta's case, they're simply authorized to have reports done, provide those reports back to the legislature. I don't think those reports would have the same weight as a decision from the Economic Impact Assessment Tribunal. Now, like I say, this is like the UARB, and the members would be appointed by provincial cabinet, so some of it would depend on how respected the members were who were appointed. If they were just partisans, well, it's going to undermine the credibility of the tribunal. But if there were, you know, non-partisan judicial or semi-judicial individuals, then I think they would have the respect and authority that would come with that kind of an appointment. The powers of these members appointed to the tribunal are the same as the powers of a commissioner of inquiry. So that was interesting. So they would be able to compel evidence and, you know, subpoena witnesses and have them come in and testify. So they'd have pretty good evidence, and then they would be able to use that in a decision which they could then use to negotiate with the federal government, or again, take the federal government to court if they feel that they've been infringed upon in their jurisdiction. The question I would have in this is whether the federal government would feel the obligation or the strategic need to participate in these tribunals. Certainly the federal government, if the question is whether the federal intrusion into provincial jurisdiction is taking place and causes harm, it would seem important to have the federal government cooperate and participate. Whether they would agree to do so is a question they would have to answer. I think if they found out that, you know, these decisions are going to be respected, that they would want to participate, although simply by not participating, the federal government could in effect undermine that tribunal by, you know, all right, well, they're not getting the best evidence because the feds aren't there at the table. So we'll see how those unfold. Slightly different approaches, but in both cases, you know, an effort to push back and assert provincial jurisdiction. But here's what I'm coming around to with the Supreme Court of Canada case, and this was the references re greenhouse gas Pollution Pricing Act, and the neutral citation for any lawyers listening is 2001 SCC 11. Now, this was a question about whether the federal legislation on carbon pricing was going to be allowed. There had been 3 cases which had reached appeal courts, one in Saskatchewan, one in Ontario, and one in Alberta. Saskatchewan and Ontario, the courts of appeal there found that the acts were constitutional. In Alberta, they said they were unconstitutional. So therefore, it all was elevated up to the Supreme Court of Canada, who decided on a 6-3 basis that the legislation, the various pieces of legislation, were constitutional. So it's a really good decision to read through. I mean, if you're, by the way, anybody that's looking for a Supreme Court of Canada decision, if you go on their website, you'll see that the decision will have a head note listing all of the parties. And this one, there were like 50 participants. I mean, the 3 provinces, the federal government, but then there were many interveners. There were close to 50 of them. Although not the province of Nova Scotia, which is interesting. Now, if anybody's following the news out of Nova Scotia and the controversy lately around carbon pricing here and that issue, Nova Scotia did not participate in this appeal. This is previous government now, previous provincial government in Nova Scotia did not participate in the appeal at the Supreme Court of Canada on carbon pricing. So didn't have an opinion perhaps one way or the other as to whether the legislation was constitutional or interfered in provincial jurisdiction, as the claim is now being made. Anyway, so the decision, so when you get a decision, you see all the parties, and then you'll have a short version of the decision. Just a few pages. You can get the highlights, the main points. And then you get a sense of the dissents. In this case, there were 3 different dissents from 3 different judges. And then you get to the long decision after that, which, can be, I think it was probably 30 or 40 pages. In this case, can be longer. So a lot of people just like to read the summary at the beginning, depending on what you're using the decision to do. Okay, so they talk about federalism, they talk about the division of powers, and reference sections 91 and 92 of the Constitution. So what the court says is that the Constitution gives broad powers to the provinces to ensure diversity across the country, but then the federal government powers are powers held which are better exercised in relation to the country as a whole. So federal issues, military issues, I guess some, federal taxation issues, international relations, things that cross border and have national aspects. Criminal justice, although, like I said, the administration of criminal justice is done by the province, but it's the federal government that sets out what's in the criminal code. Immigration is done federally, those sorts of things. So, but there's an important sort of caveat to all of that, which is if something is not enumerated in the 2 sections, section 91 and 92, then it usually goes to the federal government. Well, if it's national in scope. So if things aren't covered specifically, then you look to the peace, order, and good government clause in the introduction to section 91. So any matters that aren't covered, and if they're essential for the peace, order, and good government, POG, as lawyers would shorten it, then that's a federal government responsibility. So how does the court decide whether something is federal or provincial jurisdiction? Okay, there's a 2-stage approach. First is you look at the legislation itself and you look to what are the purposes and effects of the legislation. The pith and substance, as would be the legal phrase for that. So the purpose can be the stated purpose or the effective purpose, and the effects can be the legal effects and then the practical effects, which can sometimes be different. All right, so that's the first step. You look at what is the purpose and effects of the legislation. The second stage is to classify it as either provincial or federal. Okay, so you try to, in stage one, specify things as precisely as possible, just so, sometimes legislation can be vaguely worded or it may seem like it's talking about one thing. Often you look at the title of a piece of legislation and it seems to be saying something, but in effect it does something else. So you have to really specify as precisely as you can what is the purpose and effect of the legislation. All right. Second stage is you classify it. Okay, so if it is enumerated in one of the listed sections in section 91 or 92, well, that's easy. You just said it's all right, it's provincial or federal. Now, in cases like health, the environment, criminal justice, others where there's some provincial jurisdiction and some federal jurisdiction, in other words, there's a double aspect to the legislation, you try to figure out, all right, can these coexist with one another and operate together? And if not, if there's a direct conflict in those cases, then it's the federal government legislation which is paramount. So when Saskatchewan says they're not going to be less than an equal partner, they can't overcome that doctrine of paramountcy. If they have something that is directly conflicting with federal legislation, the federal legislation is going to be paramount. Okay, second part is, it has to be, if it's not enumerated in the Constitution, but it's something new or something that's developed into something, and it has a national aspect, matters which transcend the provinces. So in this case, with the carbon pricing, the court sided with the federal government, says yes, while each province may be able to tailor its own strategies and pricing model to price carbon in order to have an effect on the environment, it needs to be national in scope, because if one province isn't part of it, that can undermine the whole project. So that's how they said a lot more than that. It was a long decision, but that was essentially how the Supreme Court of Canada decided in that case. So when you bring it back to the two pieces of legislation that have been introduced, the Alberta sovereignty legislation and the Saskatchewan First legislation, well, all they're saying in those cases is that if it's provincial jurisdiction, we're going to assert that provincial jurisdiction. And if it's not, then, if the federal government is interfering with us, then we're going to push back. And essentially that's what they could have done anyway under the Constitution as it stands. So in both cases, while it sort of organizes Saskatchewan and Alberta to fight back against the federal government and sends a signal to the federal government that anything you do, we're going to be watching very closely, it doesn't change anything about what's in the Constitution. Any battle that could have been fought, I mean, it was fought with this decision in the Supreme Court of Canada. Nothing about their arguments in the carbon pricing reference to the Supreme Court of Canada would be different now that they have these new pieces of legislation. So I guess I would say that there wasn't a great deal of legal substance to these two pieces of legislation, but I'm sure they will have an effect in a practical sense because the provincial governments are going to be really pushing back. So that's what I wanted to say about those, about federalism, about provincial-federal relations, about the two pieces of legislation that have been introduced, and I hope you found that interesting. I'd invite your feedback on this. I hope you like and subscribe. Like the video, that helps circulate it more among YouTube users, and if you care to share, that would also help as well. Grow the audience and hopefully bring more of these videos and insights to you in the future. Okay, so thanks again to everyone for watching. Thanks for listening, and we'll see you next time.